All right, are we ready to call this to order? Thursday, June 19th, Fredonia Government Board meeting for the public hearing. We'll call to order. First thing to order is Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I see there are public comments here, but we haven't, anybody want to mention anything for previous meetings? Is that what that's all about? Just public comment? Anybody want to say anything before we get this thing rolling?
Chairman Donald, do you mind if I call the rolls? We have a record of who's attended tonight.
You can, that's next.
Okay. Chairman Donald.
Here.
Commissioner Quaid. Commissioner Rogers. Commissioner Berkey.
Here.
Commissioner Barth. Here. Commissioner Holden.
Here.
Thank you.
Now there's public comments. Anybody want to say anything to bring anything up, or are we just going to keep moving? Did we approve the minutes from the last Board of Appeals meeting? Is that what we need to do now?
That'd be the next thing, yep. Consent agenda.
My first name is spelled wrong.
It is.
Yeah. It's an easy mistake.
Make a motion to approve the minutes from August 15th, 2024 Board of Appeals with the correction proposed.
Second.
All right, now we start the public hearing. Mr. Jenkins, would you like to,
Yeah, got a call for a vote.
what?
You got a call for a vote. So all those in favor?
Oh, I thought we just did that. All in favor?
Aye.
Opposed? It's passed.
There we go.
There we go.
Now, could you let us know what this public hearing is about, please?
Of course I can. So today, the Board of Appeals is meeting for consideration by Mr. Edwin Lopez of 800 Fredonia Avenue. He's requesting a conditional use permit to be granted, allowing the operation of a CNC business with his RS1 zoned property. I gave you some details of what our ordinances read, specifically 575-51 on residential districts, conditional uses. So this lists out what type of conditional uses are currently allowed within RS1 districts. You see things like housing for the elderly, community living, photographic studios, model homes, but nothing regarding manufacturing. And then later on, if you look at our full list of businesses and where we allow them in different zoning districts, you'd see that manufacturing, even in the lightest capacity, is strictly only allowed within our manufacturing districts. Typically, this is done because of things like noise, chemical pollution, increased traffic, the increased flowage of utilities that are meant for manufacturing and industrial use that isn't quite suited in a residential zoning. So due to the above, we'd recommend denying this request because it just doesn't fit the zoning that is currently there. Later on, we'll have our attorney go through the legal steps of what this variance process can look like. But for now, it's a good summary and you guys can take it from there.
Okay. If anybody would like to speak on the behalf? You must be Ralph.
Yes. Apologize in advance if I don't see the meeting responsive to questions because I developed some kind of ear infection and I have great difficulty hearing others in the talking. One of the infirmities of media, I think. We are here because Mr. Lopez had no idea that he would not be able to continue an activity that he had done for many, many years before that, before he and his wife moved up here in order to be closer to their son in the Midwest. He has a full-time job at Carlson Tool, and he is engaged in an activity that is now creating problems here. He intends to be engaged in the activity that is creating problems here. When he first contacted me, I did a deep dive into all of your ordinances. And I think, Mr. Jenkins and council will agree that there is nothing that prohibits what he is doing, but there's absolutely nothing that specifically permits it either. There are, many, things in the ordinances that talk about permitted uses, and auxiliary uses and conditional uses. When you get beyond the point of things that are specifically permitted, this committee and the plan commission have the discretion to permit additional uses, provided that they meet certain criteria with respect to the activities and the impact on the community and on the surrounding neighborhood. I think the most helpful way to start, having read Mr. Jenkins' analysis, is to talk about what specifically he has done in the past and is hoping he will be able to do here, because he picked this house on the expectations would be the ideal location for it. He is a highly qualified and experienced machinist with a long history of working for the aerospace industry. The activity that he has engaged in uses his skills and the CNC machines that are necessary in order to take advantage of those skills to create prototypes based upon designs and specifications given to him by manufacturers and by providers to manufacturers to build things on specs to see if they will be good components in the machines that the manufacturers intend to make. He's given the specifications for those. He tools them. He obtains some specialty metals that are needed because of the requirements in this industry in very, very small amounts. And he creates a prototype. He then sends that prototype to the customer who who give him the specifications. They try it out, and if it works, they then manufacture it at their manufacturing facilities. He doesn't manufacture anything here other than uses his skills and his artistry to create these things. There is absolutely no signage involved in it. There is no traffic that comes to it. Nothing is displayed at the location that he is doing it. No one comes in to see samples or anything. No one is able to buy anything there. He simply does the work in off hours, usually on weekends, because he's fully employed. He will, if this permission is granted here, he will insulate his garage and soundproof it, because it is important that these machines have climate controlled temperatures. There will be no sound escaping from it. There will be absolutely no environmental concerns because he will not be dumping anything. He will not be disposing of anything. There will be no traffic to and from. The things that come to him will be delivered by UPS or the United States Mail. And when he has his prototype prepared, he will take it to the post office or to FedEx or whatever in his car. No one will know anything that's going on there whatsoever. It's very similar. One of the reasons I was attracted to this is very similar to what my father, who also was a machinist, did up in Green Bay many, many years ago. He had welding apparatus in our garage. He did piecework like this to supplement the the income that he was making as a machinist. And is one of the reasons that I actually was able to go to college and ultimately to law school, because I was the oldest of 10 kids, and it was indispensable that he was able to do something like this. One of the reasons I do believe that equity, fairness, I guess is the word I should use, would make it wise for this committee to approve this, is that we are in a situation of great evolution in employment, in industry, in the economy. The pandemic has created a great bit of turmoil as to people wanting to do things at home. You will have people that live here and people that will want to be coming here who will need the flexibility to do appropriate things, but in their houses. If you have the opportunity to show that you're at least open to considering in appropriate circumstances, granting this kind of permission. Another senior moment here. You do have the ability to grant this kind of permission, and I do request that you do so. I will be willing to answer any more questions. Mr. Lopez is here to answer questions. But one of the things I'd like to point out in the ordinance with respect to RS1, which is the specific category here. Mr. Jenkins talked about the generic RS category. In the RS1 category, ancillary uses would include home businesses or professional offices. Mr. Jenkins doesn't want to run a home business. He doesn't fit into the various categories that are listed there for home businesses. He's also not professional, although he's not close to being an engineer, but the kind of activities he will be doing are less disruptive of the community, the neighborhood, the environment than the ones that are specifically permitted. He has the unique characterization here of having a groundbreaking opportunity for you to say we are at least willing to listen. And that's what we're asking you to do. Do you have any questions?
I mean, I don't have any questions.
Excuse me, this isn't the time for questions. So this is just a public hearing, and then when you discuss later, then
Sure.
you can ask. Yeah.
I would say, let's see if there's anybody else that has anything else that they'd like to say.
I know next time I'll set my phone for 5 minutes. You,
When I drafted the application, I tried to avoid that. I would be prepared to do that, provided we never even having to do it. This is a matter for which you have absolute discretion. It would be extremely safe for you to say no on this, and it would not be challengeable. The only way it would be dangerous for you to do it is if you didn't believe what was said, or if some way along the way something else happened to change the use. The use as he's describing it is going to be completely compatible with the neighborhood. Mr. Jenkins is prepared to have, he's about to submit it here, a petition signed by about 33 of the neighbors and the citizens of Fredonia, supporting his petition. I do think that it would be a very wise thing for you to do to promote Fredonia and to enable the citizens to be productive here and give grant this application.
Thank you.
and that was my next question, was if I see that all the neighbors were listed on the sheet, but it didn't say if they were contacted and if they said everything was wonderful or not. And this is what Mr. Lopez has. Is it time for that now?
So we need to close the public hearing first, if there's going to be no other public comments. If Mr. Lopez would like to make a public comment, then that'd be part of this. Yep.
That would be a public comment.
Yep.
Like you were saying, I've spoken to every single neighbor that this would be affected by. And I've also spoken to a vast majority of people in the neighborhood as well. You know, I really, the only other alternative for me would be to sell the house and relocate somewhere else where I could actually do this. You know, it is an important part of my income. That doesn't mean that me and my wife can survive, because we've been very comfortable with cars and tools provided, as I said, wages, you know, who manage their second shift. But this is something that I've been doing for years. It helps me to help my community. This is where I donate, you know, most of my time. You know, when my son left our property and left my home, you know, me and my wife were left alone, and I prayed and I said, God, what do I do with my time? How can I be productive to my community? And this is the way that I've been doing it. Yeah, I don't do this to make myself any fortune or anything like that. It's more for me to be able to help, you know, local community, boys clubs and stuff like that. That I could, you know, the money that I achieve from here is gonna go to positive stuff towards it. It's not something for me to get rich out of. I already guarantee my relationship with my neighbors is more important to me than making any type of money. Any one of my neighbors that come up to me and say, listen, it's getting a little too loud out there or whatever, I will shut it down, sell the machines and be done with it. You know, but I would really hope that you guys will really consider, you know, giving this protection.
Okay, no, any more public comment?
I'm wondering how this got to the variance board in the first place. That it is an unlisted use.
Well, so they went to Plan Commission denied it. And so whenever Plan Commission denies a conditional use permit, the applicant is entitled to file an appeal to the Board of Appeals. Doesn't mean they're gonna prevail or that it's even possible to succeed, but they have the right to file that appeal.
And that's where we are now.
Did anyone, check it?
So it didn't go before the plan commission. It was denied before it even got to that point.
Oh, denied at
By the-
staff.
by the
Sorry.
zoning commission.
Sorry, it was denied at the staff level.
Yeah.
I misspoke. It's denied at the staff level, and again, anytime someone disagrees with an administrative decision like that at the staff level, they have the right to appeal it to this body.
So if we take another step in this process and request that it go before the planning commission, even though the staff made their decision, we'd like to have the planning commission as a whole look at it. And if the planning commission wants to, they can refer to the board, and the board can grant this use, even though it's not listed.
No.
It's not an allowable use the plan commission could even grant. So that's why it needs, if they approve it tonight, then you're right. Then it would go through the plan commission process of creating a conditional use permit. But it can't even get to that level because it's not allowed in our ordinances. You follow?
Is it specifically useful?
Well, we'll get into that in a minute.
As a whole, and to be, interpreted liberally. And some people say that it can be interpreted, to the letter. It depends on where you sit on that line. I don't see how this can be any different than a person giving photographs, taking graduation pictures or whatever in their home. It doesn't have the traffic that would have. it doesn't have the noise, it doesn't have anything else. This is a use, if we were to sit down and try and list every single use that you could use in a residential use, we would be here, you know, all year long till the next election, coming up with uses and deciding whether they should be or not.
Isn't that why we have the variance board? So we look at these things on an individual basis and decide whether or not it's acceptable? But that didn't happen, correct?
Well,
Again, it-
specifically, we're considering this one individual use. We're not here to change the.
We're not setting a precedent. We're actually looking at an individual.
Right,
Yes.
we're not moving the ordinance
Right.
anyway. So we would grant or deny
This
the
specific,
specific, issue over and against the ordinance.
Well, once again, I don't see a reasonable and appropriate process in bringing this issue to the attention of the field. I think we missed a few steps at the meeting simply because, we have, given authority to staff. Maybe we give them the questions, but the board can approve things that are in the ordinance.
And that would be a discussion for a community meeting, not this meeting, correct?
Right.
Okay.
yeah, I think he followed everything the way he was supposed to. He went and he applied for the proposal and then they denied it and now it's coming before the variance board to make a variance on what our policies are. That's the way I see it. Yeah. You're saying we should ex-nay this and go right to the planning commission? And have them look at it first?
Right. And in order to streamline things during this step, we changed that and allowed staff to approve some of the easier things. I don't think this is an easy thing. I think this is very, particular and sparse. And it should be taken, into consideration that it should be viewed by a full body of the planning commission. To go through it.
I would recommend that you take that up at a community meeting that, because we can't recommend that at this board level.
No, I'm not asking that you recommend it. You can't recommend something like that.
No, we can only,
I'm saying that that's the path, that's one of the steps of the path that should have been taken. It
perhaps,
hasn't.
yeah. As I read the ordinances, I mean, he followed the exact ordinances as they're laid out. So it's.
I can
it's
agree with
the
that,
appropriate
yep.
Channels according to the ordinances.
He's done everything he had to do, except check out before he bought the house that there wasn't allowed. But you know, that's not our problem, but now it is.
You still on a public hearing?
Yes, there was in the public
But we
hearing. We
discussed
closed
it
the
now.
Public
We
hearing.
breezed right through the public hearing and went to a discussion.
Because the local be directed to this committee for his application, but I'm looking at the zoning code 17.24 conditional uses. And it says the town board may authorize the town clerk to issue a conditional use permit for conditional uses as specified in the regulations after review and public hearing, which we're having right now, provided that such conditional uses and structures are in accordance with the purposes and intent of this chapter and are found to be not hazardous, harmful, offensive, or otherwise adverse to the environment or the value of the neighborhood or the community.
Sounds like a town of Fredonia ordinance.
Yeah, Attorney Ellinger, you're reading that's the town of Fredonia ordinance you're reading from.
Not the village.
Yeah.
It pretty much mirrors the same, but.
It does not. And just so we're clear about the Board of Appeals, it says the appeals to the board may be taken by any aggrieved person or by any officer, department of the municipality affected by any decision of the zoning administrator or other administrative officer.
Yeah, I was just trying to find a way through.
Yep.
It's a procedural peculiarity because I don't quite know why we were before this committee right now.
Yep. So again, to recap, Mr. Lopez cannot even apply for the conditional use permit and go through that plan commission process because that use is not allowed, period. So it didn't even get to that level of going to the plan commission. Got denied right away. That's why he's here before you. If you grant it, then he would go through the process of applying for a conditional use permit through the plan commission.
Which they could then approve or deny.
Correct. Or really, they recommend, I believe, to the village board, and that's a whole other thing, but. Yes.
Okay,
Still in a public hearing or here.
so now we move,
Want to discuss?
we'll get out of that and go to discussion.
So I
We're
think we
done with
need
the
a, I
public
think we need a
hearing?
motion to close the public hearing.
I make,
Yep.
yep, second.
Close the public hearing. Now we need to vote on
Aye. Opposed? Okay.
it.
I have a question. If this were not a business, could Mr. Lopez machine his parts as a private individual for his own use?
Yeah, might be considering manufacturing.
Yeah, I'm not so sure that I would advise anybody to consider manufacturing using, 10,000-pound CNC machines
Well,
as.
whether we advise it or not, could he?
Well, that's what I'm saying. If a plan commission or a village board came to me, I look at the code, right? So I'm gonna start with the language of the code, where it talks about permissible uses in the single-family residential district. And the purpose is for single-family residential development. And just the general provisions in our use regulations, that's in section 575-9, where it talks about uses that aren't specified in the code. The village board would have to find that they're sufficiently similar to a specified permitted use. And to me, that means
Yeah.
something that is sufficiently similar to a residential use. And
So if this were a hobby of his,
I think you get to a point where it becomes intensive enough that the hobby can't take place in a residential zone. Right? Like I could,
well, I don't know, I mean, the house that we moved into had a big old welder right in the garage, I mean. Whether we agree with that or not, I mean, I didn't see anything that specified that he couldn't have had that.
I mean, I could have a hobby of flying helicopters, but that doesn't mean I can
Well,
land them
right,
in the
Right,
backyard.
but that would be, but
But
you're
you-
subject to other laws, right? So.
But you see, the point I'm getting at is
Let me ask this, Mr. Lopez, are your machines governed by any federal administration or state administration that says, here's how you have to navigate them? So they're specifically, if you didn't want to protect them in terms of the environment around them, you could just let them be what they are, correct? Yeah, I mean, it certainly would destroy the machine faster.
Yeah.
But you could do whatever you wanted with it. There's no federal law that we are aware of. There's no state law that we're aware of that would otherwise govern the use of those machines as a hobbyist. So that's kind of, I guess that's kind of my point, is if he could do it as a hobby, it really wouldn't change anything now that he's charging specifically for it.
Except for the fact that he is charging himself.
Oh, correct.
He's charging businesses for it, which means he's gonna
Correct.
have all the.
No, it's absolutely for business use, but the use is permitted. If it were if he were a hobbyist.
I guess I disagree with that interpretation, so I'll just
Okay.
go on record as saying that.
Okay, I guess I'm not sure, I don't. Again, in my review, and maybe I missed something in preparation for this. When we have the ability to specify the use of something that is not over and against what the law would otherwise, or the ordinances would otherwise say. Right, so. Our ordinances do not prohibit the use of such machines as a hobbyist.
I think you're reading the code in the wrong way. Let me
Okay.
just put it
That's
that
fair
way.
enough. I'm willing to be corrected.
I think. Well, let's step back. First, in order to grant a use variance, both under our ordinance as well as under state law, this board would have to determine that none of the things that are listed as permitted or conditional uses in the zoning district are applicable. In other words, someone has to, in order to get a use variance as opposed to an area variance, you have to say, if you don't give me this variance, I can't do anything with my property. And just based on the record that's before us, I don't think that's the case. Obviously, the property can't be used as a residence, right? So that's why use variances in and of themselves are nearly impossible to actually get. As opposed to an area variance. Area variance being something measurable, like I want my garage to be closer to the setback, or I want a taller fence than the code. Those are things that come before this board relatively frequently, that pretty much frequently get allowed. Use variances, the law treats very differently. So just on that standard, it'd be very difficult to say that they're entitled to a use variance. I think what you're asking is, can we somehow interpret the code to say that we don't even have to give a use variance, that this is just a permissible use in the zoning code, the way the zoning code reads to start with? That's sort of the question that I'm hearing.
No, I would say we would still have to grant the use variance. What I'm saying is because it otherwise would not be prohibited as a hobby. Like, for instance, could someone have as a hobby setting off or creating and setting off giant fireworks in their backyard? There's a specific, and this is just as a hobby, right? I mean, but there are specific ordinances that would say no to that. Because we don't allow the setting off of fireworks within the village.
Yeah, well, and that's maybe not the best example, because that's a separate activity as opposed to a land use that we put into particular districts. I'm sorry?
I was gonna say, and it's unlawful to blow off fireworks. So, I mean, I see your point.
Yeah,
But this isn't something he's gonna do every single day, every single weekend. It's gonna be when they call him and he has to do it maybe every month or something. It's not like there's gonna be traffic going in there all the time.
Gene.
I think that has to be put into the planning commission because that's the next step after this, right? We need to make recommendations that if we were to pass something like this, that has to go into the planning commission, that it has to be.
Well, the planning commission has to put their own, we would just be granting the variance.
Yes, we can't put stipulations in.
I don't think we can.
I know we put something when the dentist went down here, we didn't like the fact that he could see his garbage can. So we said, okay, you can do that, but you have to put a fence up there and you have to put some shrubbery. You have to make it look like it's more residential than, you know, a corner lot with garbage cans hanging out. So we did put some kind of stipulation in on that years ago.
so just procedurally where this is at, because this was denied at the staff level, it was couched in terms of a request for a variance. There's a couple different ways you could look at it. One is that they're requesting a variance. The other is just that they're simply appealing and saying that the zoning administrator got it wrong and they should have allowed this to go to the plan commission. If you grant the variance, you're just granting the variance, and they get the variance and they can do it. So it doesn't then go back to plan commission if you decide to grant the variance. Again, my advice to you is that you can't grant a use variance because it doesn't meet that very high standard for granting a use variance.
We could, instead of granting the variance, ask it to go to the planning commission.
And there you would have to find that the zoning administrator made an error in interpreting this. And again, that gets to the second part of this, is looking at the way that the village board has put the village into different zoning districts. And in each zoning district, it says some things are permitted uses, some things are accessory uses, and then it lists some things that are potentially conditional uses. And the village board has done that. So we have to live within the constraints of what the village board has set. And the village board would have to find that a particular use is sufficiently similar to one of those things in order to be permissible. And just my advice to you, or the way that I see the record, is that this particular use is not sufficiently similar to any of the things that the village board says can be done in a residential district. It's really not at all like having a photo studio or a bed and breakfast or a sales house or any of the other things that are residential. It's manufacturing. And the board has, you have to take a look at the zoning code as a whole because the board has decided what zoning districts that manufacturing activity they want to take place in. And the board has said, we want manufacturing to take place in these particular zones. So it's not just a question of, well, could they do it as a hobby? It's still a question of how is the land actually being used? And because the land would be being used for manufacturing, whether or not it's for just personal enjoyment or for a business purpose, the village board has already made the legislative determination that manufacturing activity is supposed to take place in those industrial zones. That's the reason why, a factory isn't going to go in next door to your house, or a meat processing plant isn't going to go in next door to your house, because the board has decided that those need to be in particular places.
Does our code have a definition for what manufacturing? I looked for that, so that was that interpretation. Wait,
There is a definition, it's at 575 dash, well, it's in Article 15 of the zoning code, so it's 575-124. So there's three different types of manufacturing: heavy manufacturing, light manufacturing, and medium manufacturing. Light manufacturing is an establishment engaged in the indoor manufacturing, assembly, fabrication, packaging, or other industrial processing of finished parts or products, primarily from previously prepared materials, or the indoor provision of industrial services where there are few external effects across property lines. This term includes, but is not limited to, a business engaged in the processing, fabrication, assembly, treatment, or packaging of food, textile, leather, wood, paper, chemical, plastic, or metal products, but does not include basic industrial processing from raw materials. Medium manufacturing has a list of items that it includes, and one of them is fabrication of metal products. So that's medium manufacturing.
The problem that I have with this is it sets a precedent, right? And Attorney Ellinger's even said, when you'd be taking a step, you'd be welcoming things, you'd be taking a chance and things like that. What I don't like about that as a body granting a variance for this is saying, yes, maybe we do agree that you're having absolutely no impact to your neighbors and things like that, right? Maybe we do, but the fact is we would still be granting a variance for something that's specifically not allowed in the zoning that is in this particular place. And it opens the door for all sorts of other people to come and say, well, you granted for this, you granted for that. And at the same time, maybe I agree with Donnie a little bit in the sense that maybe it would be something that should have been discussed at the planning commission. That's not how we're set up at the moment, right? So that's why we're here for this. And I think that we need to take into consideration all the effects, no matter what our decision is here. We can't recommend to the planning commission. We can't say, well, we need to go to community forum. We are either approving this or we're denying it, right?
Yeah.
And we have to look at all the effects that it could be on the community. It could be on the community now, moving forward. And also, what can maybe be changed as a result of this process here today. Maybe it's something that needs to be changed at the board level, at the planning commission level, something like that. Who knows? But that's not for us to determine.
I thought as a variance board, we're not setting a precedent. We're doing on an individual basis and we're looking at it individually. So it isn't a precedent. If somebody,
There's always a precedent set though. Oh,
Well-
we went before that.
But it doesn't mean.
Doesn't mean they-
we'd ever have to do it.
What does it?
But
I'm
Yeah.
just pointing that out.
I understand what you're saying.
I don't know how often he uses his equipment over there. I don't know if it's, if it matters, if it's, you know,
4 hours, maybe 7 or someday, because I really have to take care of my property, first of all.
Oh, sure.
That's a full-time
well, it's
job.
prototype work. So you get, when they ask you to do it, you do it. And then there may be months in between where they don't ask you to do anything. So it's not like it's a manufacturing facility that's
No, I
pumping
get
product out.
100% understand that.
My concern is that that's how it is right now. What happens when his business picks up in 6 months and he's running that machine 4 hours every day? And what happens if his business picks up even more than that 6 months later? And now he's adding a third or fourth or fifth machine, and now he's adding onto his garage. There's, yes, what if?
I
But
beg to
there's
differ.
so much businesses grow, and we understand that, and I would
I
hope
don't
that
have
it
any
does, but.
employees. It's just me. And I'm 59 years old. You know, and as much as these companies want me to open up a big industrial place, I could have 10 employees under my command. As much work as they want to give me, and I limit them just to 1 or 2 pieces per real estate. You know, because I'm way too old for what you just explained.
I get that. I think, you know, and I feel for you because I'm in real estate, right? That's what I do. I'm in real estate development and buying and selling buildings and also buildings. A little frustrated that whoever your agent was didn't talk to us about this. Honestly, I would think that maybe that'd be the bigger beef for you to have would be with them. But I know that, you know, the old saying that ignorance is not an excuse type thing, right? We have to consider that at least a little bit too. I feel for you, I really do, and this is a tough one for me because I can tell that you're not gonna be running this machine 8 to 10 hours a day and all that stuff. I really can understand that. But I think, you know, we just have to make sure we look at, these are the ordinances that are in front of us. This is what has been set. Does this conform to what those specific zoning requirements are? And I think that's where we have to make our decision.
And how do you go about changing the variances? You have to go before the planning commission and submit, I mean, we don't.
That'd be at a board and a committee level and staff level. That's a great question.
In circuit court,
Correct.
is there anything that we can do besides having both government and spend all that money going to circuit court?
They would have to,
To the planning.
well, it can't go to, it wouldn't be planning commission because planning commission has to live with the legislative decisions that the village board has made in terms of what the village board has said are the allowable either permitted or conditional uses in that zone. The village board, if they wanted to do a text amendment to the zoning ordinance, whether it's the permitted uses or the conditional uses in that particular zoning district or in residential districts, generally speaking, to amend the actual text of the zoning ordinance, so that wouldn't just apply to this person's property, but to allow whatever the village board decides how it wants to word it, to allow manufacturing, you know, hobbyist activities, whatever the situation is. That's a legislative decision the village board has to make. And then once that framework is in place, depending on how, if and how the village board decides to do that, then perhaps this individual or any other individual could make the appropriate applications or do what they want to do in line with what the village board has decided. But the planning commission, staff, this board has to deal with the zoning ordinance that the village board has set and the uses that are in place right now.
The planning commission can give a recommendation.
Oh, they can only give a recommendation on a particular application that comes in. I suppose if there was an introduction of a text amendment to the zoning ordinance, that may go to plan commission first to recommend to the village board, but the village board could also just take that up of its own initiative, because ultimately that's a governing body question.
Worst case scenario, what kind of timeline are you looking at with something like that?
That's a 4 meeting process.
Yeah.
That changed the zoning code. So it's 2 meetings at the plan commission and 2 meetings at the village board.
And there's also, you have to look at what, I assume we have a comp plan. So you have to look at the comprehensive plan that's currently in effect to see whether that proposed change is in accordance with the comprehensive plan that's already in effect. For where the different, what's allowed in the different districts and where those are located, so.
Mr. Lopez, how much of this is putting you out of work right now in terms of this specific manufacturing thing? How much of this is putting you out of work in terms of like, I mean, I know you've got your full-time work, but are your clients missing their prototypes? How long are they willing to stay with you that way?
They've already been. I moved here in January, so we're already 6 months into this process. I asked for a permit for 3 days, and they gave me, the village gave me the permit for the 3 days. And then they called me Tony, functions there. I don't see.
A permit for the rephasing of.
He's electric.
Three-phase electric to
Oh,
run his
thank you.
machines,
Thank you. Yeah.
which is not residential. You know, so they allowed that. They, I don't know, I'm still stuck on your whole hobby thing. You know, if somebody has a lathe and they want to make bowls out of a piece of wood, we're gonna say they can't do that, or they have to have a permit for it. I mean, it's a hobby. This guy's working, what, 10 hours a week maybe in his garage doing this stuff. It's more of a hobby than a job. Not that that matters. I'm just saying that it's more of a hobby that it's not industrial. It's not heavy industrial.
My hobby is smoking pipes, and I sit in my garage doing that longer than you do this. So. Tobacco pipes for the record. Not the only thing.
Make sure you write that down, Michelle.
Yeah.
I second that. What's that?
Well,
Sure.
I guess the public hearing is closed, so at this point, I'm, you know, it's up to the chair, but this is really the part for the board to be deliberating.
That's why I have.
He said, sure.
Yeah, go ahead.
Thank you. I noticed when you first addressed the machine itself, you were referred to it as some 10,000 pound machine. Would there be a difference if it was a high value machine? I sense,
Possibly. I mean, I think that again speaks to the intensity of the use and whether what's happening is something that is sufficiently similar to what would be in a residential, considered a residential use versus something that's an industrial use. Just like me flying a model helicopter out of my backyard is different than landing a Bell and helicopter in my backyard. I mean, the bigger something gets, the less it's like something residential.
I guess where I'm caught up is, I feel like this is residential use. That's my problem. I understand that it's commercial, I understand that it's in some sense industrial, but it's residential use.
It's not a business that would benefit by going to the industrial park and renting out a little shop down there. And now you're paying taxes and then it's a hobby. I mean, there's not enough revenue there.
Yes.
But there's still revenue, so it's still
Yes.
business. So we can't just pretend it's not a business.
No, but
No,
there's other things that are functionally residential use that are business oriented within the ordinances, right? Because I mean, you can have, well, they're all there. You could have a housing for the elderly, you can have a photographic studio, you can have a model home, you can have commercial greenhouses, you can have a bed and breakfast. All of those are commercial uses, but for residential use.
Right, but as our attorney is saying, is that what you're primarily trying to use the property for? And here, if I'm explaining that correctly, and here we're saying he's living there, this
Yep.
is for his house, he just also wants to use.
But
it
a
for-
commercial greenhouse is not gonna be primarily use that's not the primary use of the property. The primary use of the property is to live upon, right? This is a secondary use.
Right, I think the point I'm making is that because the village board has decided that these are the allowable conditional uses, in order to permit a use, you have to find that it's sufficiently similar to one of these to be permissible. So,
I think it is. I know it's manufacturing, but I think it is.
Well, if that's the case, then we should take a vote on it. I mean, that's.
No, I don't, and I don't disagree. Are we able to put conditions on a variance use? So if we grant the variance, are we able to say,
X amount of hours.
well, and that's part of the, I guess, just the procedural problem of what we have here, because it's a little unclear as to whether. So the applicant filed this as a request for a variance. And the variance that is requested is to permit as an accessory use, which I don't think is correct. I think they meant conditional use, the operation of CNC machines in applicant's garage. And then the application talks about granting it as a conditional use.
Doesn't
Yeah.
matter how heavy the machine is. I'm a manufacturer. I do machining, and 10,000 pound CNC machine doesn't make it more or less industrial. It just means it takes that to make that part. But
So the problem is, and again, this gets back to what I was saying before. Use variances are almost impossible to legally grant, and that is the way they have brought it to you. If what they really meant to do was simply appeal staff's determination and say, no, we're not asking for a variance, we just think this should have gone before plan commission to evaluate as a conditional use, that's really just an administrative appeal. And so I guess to the extent you're construing it as an administrative appeal and you want to say, no, we think staff was wrong, we think this could potentially be a permissible conditional use, so we're going to reverse staff's denial and send it to plan commission to go through the hearing process in plan commission. I guess I would let Attorney Ellinger decide whether he's open to this board construing it that way, but you could do that. Otherwise, for the variance itself, you are either granting or denying the variance. So my strong advice to you is you cannot grant a use variance, and that's not anything really particular to this case. It's
Right.
pretty much any case. You can't, it's nearly impossible to actually grant a use variance. If it really is meant to be construed as an administrative appeal to say that staff got it wrong, again, I still don't agree with that, but I guess if this board wants to construe it that way, then they would essentially be reversing staff's decision to deny, in which case it would go before plan commission. Plan commission will do its thing, and then it could be right back before you if depending on what plan commission decides to do with it, so.
Who sent it to plan for a conditional use?
What's that?
Who ended up with the variance? I believe the variance was probably instructed by our, zoning administrator. And you filled out a variance and this and that, and here it is, and now it's dead end for it.
I don't know whether that was filled out by the applicant and then the attorney letter came later, or
But
So again, we denied that it would even go before, we denied that it's an allowable CUP. And so according to the ordinances, if staff denies it, then they have the right to an appeal. And then it goes before the Board of Appeals.
so the applicant. So, follow the process. You should follow the path of going to the, planning commission.
No, you're misunderstanding me. I'm saying before they're correct to come before this body. It's a question of what they're asking this body to do.
At 59.
No, he applied for a permit.
Yeah.
He applied for a permit the way he was supposed to.
Right.
It was.
As the ordinances are written by the village board, administration has the authority to either approve or deny those applications. In this instance, they denied the application. Mr. Lopez has the right to then appeal it and come to the Board of Appeals to try and reverse that decision.
And that's what I'm saying. There's two different ways of what you're asking this body to do. One is to say, essentially, yes, staff was correct to deny it based on their reading of the zoning code, but I'm asking this board to give me an exception. That's a variance. Make an exception for me. Here's why I should get to do what I want to do. The other is to do, it's really more of an administrative appeal and say, you know, I think staff was wrong in the way it interpreted the code. So I think staff was wrong to deny my application. You should reverse staff so that I get to go through
Fine.
what would have happened if the staff hadn't denied my application. Either way, it goes from staff to here. The question is exactly what it is the applicant is saying. The way the applicant has framed it and filed their paperwork up to this point, they're just asking for the variance.
Yeah.
They're saying,
Although the attorney addendum, I think is could be interpreted that way. I think it also could be interpreted, let's get it to the planning commission, like we need to reinterpret the law.
We should have asked for a conditional use permit instead of a variance, and that would have been a whole different bailiwick. That's what I mean, we'll say that Jenkins shouldn't have denied it and that he should come back and ask for a conditional use permit.
So that's an administrative appeal. So that's what you're
it's an administrative appeal. And then you can decide on that basis whether to grant or deny the administrative appeal. Again, that's up to you to deliberate and decide whether you think staff actually did interpret the code incorrectly. Again, I'm not, my legal opinion is I'm not seeing it, but that's for you for it to deliberate and decide.
In front of us, page, this one.
Village ordinance 575-51.
At the Board of Appeals, June 1925, it's what the special CUP.
Well, that is
How
the
exactly-
conditional use.
Exactly, is it listed in there, in the ordinances? What's the language of the ordinance? For that, because, so we've got the listing of things that are permitted. Is the introduction to your A, B, C, D, E, F, is that the way that the ordinance is
Yep.
worded?
Yep, there's a copy from the ordinance.
So based on that, I don't see that, the administration didn't follow the ordinance. They
So the-
followed what they were supposed to do.
And
The ordinance does not allow this.
if you step back and look at 575-16, which is, that's your zoning code for the RS1. It lists your permitted building structures and uses, then it lists your, hey, let me finish, Don. It lists permitted building structures and uses, then it lists permitted accessory building structures and uses. And then it lists conditional uses. There's three things in 575-16 that are listed as conditional uses. The first thing is attached garages in excess of those allowed as permitted uses. The second thing is large accessory structures such as pole buildings or similar. And then the third thing simply directs you to this list right here. So those are the three things that are listed as potential conditional uses in the RS1 zone.
Potential or actual?
Say that one, I'm sorry, say that one more time.
Potential uses or actual uses? It lists these as potential uses.
Right, I guess what I'm saying potential is this is the universe of things that could even be contemplated as potentially being granted as a conditional
I see.
use.
My opinion is this is not administrative appeal.
Okay,
And I mean, I would agree.
I'd say under the way that this is written, I would have to agree as well.
Did they hold their position in advance until the board had time to act?
That's up, it's up to the board now to deliberate, so.
I don't know, if there were certain times, certain hours, I think we can't put those kind of stipulations on, say he can use it or he can't use it. So that,
Planning commission.
I mean, I really want this, I want this to happen. If you like, not just for Mr. Lopez, but I think it's appropriate for it to happen within the village.
If you want this to happen, then we have to treat it as an administrative appeal. And we have to direct it. We have to decide whether or not we believe that the administration got it wrong. That is the only way for
Yeah. Otherwise, it has to start with Mr. Lopez or whomever bringing it up to the village board for consideration at that level. Right.
the administration has to go back and look at their interpretation. And
Well,
decide
I mean,
whether or not it's
so-
interpreted.
So the way that I guess I'm hearing on it, like, again, Mr. Lopez, I want this to happen for you. I wish I wish I could make it for you. I don't know that I can make this happen, right? Because I agree with the village. I think you guys interpreted it right. But I think we need a different language there. So the thing that I would suggest is, would Mr. Lopez come to a board meeting and ask them to reconsider the language?
Yeah, I mean, like any other citizen, you
Yep.
can
Okay.
go email your village trustees and village president and say, you know, hey, I've got a problem with the way that the village zoning code reads right now.
Yep.
I would like the board to consider changing it. And then it's really up to the trust. It's not an application.
Yeah, we have a
process.
process laid out that we
Right.
can explain to Mr. Lopez.
And other than time, if we deny this right now, is there anything lost to him? If we say, sorry, it can't happen, he can come right back to the village board, correct?
Yeah, there's, the village board can always decide to change the zoning code. But as your clerk stated, a zoning code amendment is a process because the public has to get notice and there's public hearings and publications and you have to review the comprehensive plan and it's not.
That's,
Sure.
you know, those
Right.
Yeah.
zoning code, the zoning guidelines were put in place for a reason, right?
Yeah.
To protect not only you, but also the entire village.
Or we can take that particular authority in the zoning instructor. In cases where there is a conditional use, the county commission will get it.
But again, they cannot get to the plan commission if it's not an allowable conditional use. So I mean, that's all, I mean, it has nothing to do with my position, Don. It's just, it's not allowed, so it can't even get to the plan commission.
And according to the bylaws of the village of Fredonia, this is not allowable conditional use.
Get that answer out for the president.
So if you want that, then the applicant should ask the village board to amend the zoning code to allow this type of use.
And then
And-
we could be called back.
Was that
We could be called back if it doesn't go this way. Is that correct?
the ordinance change or his application?
The application.
Yes, so if the ordinance, change process happened, right, it becomes allowable, he goes through the conditional use process through plan commission and village board, and they deny him, then yes, you could appeal that denial and come back before you.
So I think the appropriate thing to do, and I will do it at this point, because I believe that this needs to go in a different direction than what it is right now. And trust me, I do feel for you at this point, but I am going to make a motion to deny the variance request.
I second.
According to, yeah, I mean, that's the way it reads. I think that you can come back and go go to a village meeting and planning commission. You have an advocate here to help move that along.
All right.
But
And
I
I think
agree.
we probably have quite a few advocates within the Fredonia community.
You've lost the scrimmage, but not the battle, maybe. But according to what we've got here,
And I hope that, if the vote goes the way the game's gonna vote, I really would hope that you do not move out of Fredonia and that you can help spearhead this issue. Because I think, I hate to use you as kind of what do I call it, the trailblazer?
Guinea pig.
Martyr?
The guinea pig, the trailblazer.
Yeah.
And I agree with,
yeah,
Make the
as
change.
do I.
I
Read
just,
it and make the
Yeah.
change.
yeah, it won't be very hard.
already been a costly process, just to get to this point.
I understand.
Mr. Lopez, you and I mean, we still have to take a vote, but you and I could chat after the meeting or, you know, on Monday about what that process looks like, and you could decide whether or not it's something that you'd like to participate in. I'm not sure that there would be any cost to you besides time.
Okay.
So
Yeah.
let's chit chat after the meeting about what that process would look like for you.
But
All right.
I really do.
Make your
hope
motion,
that-
Ian.
That you specifically stay here because it needs an instrument of change. And me arguing for that at the board level is not gonna make a difference, but you arguing for that, I think absolutely would. So if I can commend you to do anything, I hope that you don't give up on Fredonia yet.
And I can tell you and for Don and the others who are here, I think one thing your zoning code does not have that many communities do have is some sort of a home occupation. Whether it's a permitted use or a conditional use, or some home occupations are permitted, some home occupations are conditional. That really gets into, to your point, what can you do, whether it's for business or not, at home? The code, your code as it reads right now, pretty much just says, except for these like very
Yeah.
two specific things, not much.
Yeah.
I think a lot of other communities have a little bit more robust a home occupation type setup in their zoning code that would address all sorts of different issues. And again, how the village board decides to address this type of use is gonna be up to them. But
That's a question.
Mr. Lopez, did you have one, something, make a comment?
I did read and news that, engineers should be able to do business in their homes, in the residential homes. And what I'm doing is actually considered manufacturing engineer. If you really look at it, this is scroll technique.
Can you,
I have
find where
been
that's
an
in-
attorney at the time, but we've been,
is that in the town?
it might be, I don't know. It's not in ours.
Yeah.
It's the manufacturing part of the engineering concept that is at question here, not the engineering part. So, all right, I make a motion that,
Well, I think you already have a motion that's been seconded.
Just got to call
So
for a
now we,
vote.
now we take a vote on the motion that has been promoted. All in favor, say aye.
But this is a motion to deny, so if you are voting in favor of this, you are voting in favor of denying it.
Correct, yes. All in favor of denying the application?
I,
Aye. Reluctantly.
Any opposed?
Any noes? All right,
Thank you.
I make a motion to adjourn.
second?
All in favor?
I.
All opposed? Nobody?
Thanks for your help.
Don, I warmed your seat for you.